A very warm welcome to all of you, and thank you for tuning in this episode of UK-ASEAN Business Council Digital Expert Series on protecting your intellectual property in Southeast Asia. I'm Veronica Lake with the UK-ASEAN Business Council based in London. Today, we are delighted to have Christabel Coe, Regional IP, Business and Trade Advisor at the Intellectual Property Office, and Victoria Armstrong, Senior Associate and Registered Foreign Lawyer at Taylor Winters VIA. They're both joining us from Singapore for this discussion led by UK-ASEAN Business Council's Director of Trade, Paul North. Before we begin, I have a couple of housekeeping notes to highlight. Firstly, as you can see, you are all on mute, but this does not stop you to engage with our speakers throughout the discussion. To ask a question or to make a statement, open the question box on your control panel. We will make sure to direct your questions to the speakers during the Q&A session. Secondly, please note that the presentation used today, the recording of this very webinar, and all contacts of our speakers will be shared with all of you by tomorrow. Thirdly, a reminder, the next episode of our Digital Expert Series will be on higher education. We will be joined by DIT's International Higher Education Specialist from here, London, DIT's Head of Education for Asia Pacific joining us from Kuala Lumpur, and the Director of Education for the British Council based in Singapore. And now, to guide you through a discussion on the importance of protecting your IP in ASEAN, I'll hand over to our Director of Trade, chairing today's discussion. Paul, over to you.
Thank you, Veronica, for that very warm welcome. And good morning, everybody in the UK, and good afternoon to all our listeners in Southeast Asia who have joined us. Before we hear from our experts, Christabel and Victoria, just let me set the scene for those discussions and give a small insight into ASEAN and UK-ABC. Next slide, please. Thank you, Veronica. The countries you see on the slide complete the Association of Southeast Asian Nations, ASEAN, established in 1967 to accelerate cultural development and economic growth and social progress throughout the region. ASEAN countries are all very diverse, economically, culturally, and politically, from the high-tech market of Singapore to the recently opened up market of Myanmar, a country that has nothing and needs everything. ASEAN has a young, dynamic consumer market with a population of over 640 million and an average age of just 26, which has created a huge middle-class consumer base where GDP per capita has seen a 70% growth over the last decade. It is where the growth is, or was pre-COVID, and like all markets, has seen a decline in its economy. However, it is predicted that because of its strength, ASEAN will be one of the first economies, if not the first region, to bounce back, and even more strongly. Next slide. So where do we fit in to all of this? The UK-ASEAN Business Council is the leading UK-based organisation promoting trade and investment between the UK and ASEAN's dynamic markets. Not just there to drive that pipeline of UK companies looking to do business with Southeast Asia, but also acting as a conduit for ASEAN companies looking for partnering here in the UK. We help companies of all sizes build new contacts, provide market insights, and raise the awareness of the vast commercial opportunities available to them. We also bring ASEAN to the UK through a sustained calendar of events, and would really encourage you to visit our website where you will find all you need on doing business in ASEAN. So without further ado, I'd like to hand over to Christabel, who will talk about protecting your intellectual property in Southeast Asia. Over to you, Christabel.
Thanks very much, Paul. Hello, and thank you for taking time to join us for this session today. Our thanks also to UK-ABC for setting this up. In the next 20 minutes or so, besides learning more about us, the IPO, and the resources that are available for you, we will be covering the essentials of intellectual property, IP in short, in Southeast Asia, and hopefully we will be able to be in touch beyond this session. Allow me to first introduce, by starting off, to introduce myself and the IPO. I'm Christabel Koh, and I work for the UK Intellectual Property Office. I'm based at the British High Commission in Singapore, while IPO is based in Wales, and also a smaller office in London. It may be a little bit unusual, but it all makes sense in the next slide. Why do the IPO has attaches like us based outside the UK? One of the primary duty that I do is to advise British businesses on IP business and trade matters in Southeast Asia. So what does the IPO do? IPO is an executive agency. For those who are not aware, we are within the Department of Business, Energy and Industrial Strategy, based in short. It is both rights granting and policy making agency. We also proactively focus on IP education and outreach in such a session like this, as well as supporting IP enforcement in the UK. We have over 1,000 staff in Newport and a smaller office in London, including 7 IP attaches like myself, based outside the UK, covering various markets in Beijing, New Delhi, Geneva, Sao Paulo, Washington, and Singapore. But given the current circumstances everyone is facing, most of us are working from home. Now, the agenda for today, I would like to cover these are the 3 areas I would like to cover. First, I will cover what is IP in brief, what are the main types and the importance of intellectual property for business. There are many forms of IP around us, in the products we use and in the business you own. That includes your trading logo, your company website, business know-how, and many more. These are proprietary to you, your company. Trademarks for brand identity, we are familiar. Most, if not 100% of businesses do have some form of a trade name, a brand identity, and the logos that are on your business cards. Patents for invention, designs for the way objects look, domain names, most of us these days would have an online representation on websites, and those are your domain names. Copyright for written and artistic works, and others include confidential information, trademark, trade secrets, technical expertise, sector knowledge, and others. One of the takeaways today is to know what are the different forms of IP, so you could identify what are your intellectual property. To give an example, your UK or home trademark and patent registrations will not protect you in an overseas market. There is no such thing as an international copyright that will automatically protect an author's writing through the entire world. Protection against unauthorized use in a particular country depends on the national laws of the country. However, most countries do offer copyright protection to foreign works under international agreements. Patents are generally granted on a first-to-file basis. Similarly, trademarks are generally granted on a first-to-file, but for some countries, it is based on first-to-use. So you should consider how to go about obtaining patent and trademark protection before introducing your products or services to markets overseas. We mentioned earlier that IP rights are territorial. What that means is you will need to register your rights in those countries of interest. There are 2 ways to go about registering IP rights. Through one, the national system by filing directly with each of the IP office in country. So for example, if you are interested to pursue the UK as a commercial market, that's your home market, you will need to file your IP rights with IPO in the UK. And likewise with each of the IP offices in your country of interest. Or the second way to go about is, we mentioned earlier about international agreements that are available previously in the previous slide, is to register your rights with the World Intellectual Property Office, World Intellectual Property Organization. It is a UN IP agency that takes care of international systems. So if you can see this table in front of you, PCT is a system that is in place for patent application, Madrid system for trademark, The Hague for design registration. We are happy to have a specialist with us today after my sharing, who has the technical knowledge of these details and how it may be part of your business IP strategy when you embark on the journey of protecting the IP in Southeast Asia. For a close to part one, I would like to highlight the importance and value of IP and broader intangible assets, IA in short, in a modern business environment. These days, intangible assets, of which IP is a subset, are forming an increasingly large part of the business value. In previous years, the vast amount of a company's value lay in its intangible assets such as buildings, machineries, and equipment. However, nowadays, with the ever-increasing number of new software-based companies covering a variety of sectors, the value of many companies may be comprised of up to 80 or 90% intangible assets. This is especially evident in the software sector, for example, where early-stage companies require little more than a few computers and don't have the overheads of office space or equipment previously required by many businesses. The development and licensing of an IP asset may be successful business in itself. A good example we would like to quote is the ARM Holdings. Some of you may be familiar. They are a Cambridge-based British semiconductor and software design company, which licenses its IP to tech giants such as Apple and Samsung. They were acquired by SoftBank in 2016 for £24 billion. So that's the value and the potential of the IPs if you are able to use them as part of your business strategy. So what is IA vis-a-vis IP? And IP will be some of those mentioned in the previous slide, where they are legally registered and enforceable, where IA are undisclosed and people-based assets that extends beyond IP rights. IP and IA, when used cleverly, is a multi-dimensional asset to protect valuable creations and inventions your employees, the company comes up with, to raise barriers of entries against your competitors, to create brand recognition and loyalty, to generate more revenue for you, to forge better and strategic partnerships, to attract investors and partners in the different countries. This is where IP management comes in, and where you need to know what is valuable to you and your company through exercises such as IP audit, to check what are the different IPs you have, IP business planning, and eventually a strategy to enter the different markets. Find out the most cost-effective way to conduct due diligence, market monitoring, and protecting your IP rights, and how to generate value and revenue from your IP assets through licensing, through direct sales. Do not protect for the sake of protecting. IP does a lot more if you use it cleverly and strategically. The second area I would like to cover is Southeast Asia in brief. IPO's support and resources that are available for you. We have heard from Paul earlier when we start about ASEAN as a whole, the market. So these are some of the quick points that we have. Southeast Asia, if you do not already know, is an interestingly diverse region with high potential business opportunities, but legally fragmented. It has 650 million people. There is Brunei on one end with 430,000, but on the other end, a place like Indonesia has 270 million people. And if we take an example, if we look at the GDP per capita, you'll find Singapore topping the chart for GDP with close to 6 million in population. We have heard from Paul about our export, the UK's export to 6 of the largest ASEAN economy combined is equivalent to 3 times more than export to Brazil, twice India's, and 50% more than Japan. These numbers make sense during the pre-pandemic days, but it's illustrated here to allow you to appreciate the potential of the region. I'd like to move on to the second point on tools and support the IPO has available for you. Sorry, we can go back to the previous slide. I'm covering the last part. In 2013, we helped British companies resolve IP issues worth almost £115 million. Since inception, we started in 2012. Through one-to-one direct business outreach and support, the network has reached more than 33,000 companies wanting to operate overseas. Now, in Southeast Asia alone, in 2018, we supported over 1,200 businesses from the UK, ranging from micro SMEs to large MNCs on matters related to IP in the region, from registration all the way to the end of the value chain, enforcement, and the contracts that comes along, where IP plays a part. So our encouragement is contact us early at the early stage of trading, when good advice is most important. We give advice on good IP and related options when entering the region, and where you can get additional support or when you need additional legal advice. We offer the UK businesses free and partial IP advice. However, we are not lawyers, but today we have Victoria with us today as a fellow speaker. So while IPO is unable to advise you on legal matters, you now have at least one valuable contact in Singapore who is able to help you navigate some of the IP-related risks in the region. However, we are your sounding board to partner with you in your journey. This is a practical aspect where SMEs in particular should reach out to us, the IPO. And we have resources, free resources to point you to, both in materials as well as access to expertise in local markets. So what to look out for that you can navigate the risk of expansion that can cause millions of pounds of loss when trading in the region. There are successes of business venture to the region when they make conscious effort to manage what is proprietary to them. In my last section, I will be sharing a case study, so that will give some light to the stories. But in the next few slides, these are takeaway slides for you. We have kept some links that are available. First, consult publications and websites. There are many materials that are relevant, that are useful for you to know before you go. 2, attend IP awareness, such as this session. Pre-2020, we have a lot more physical roadshows across the UK. But today, we do not fall short of many webinars and recorded sessions, giving you more access to information for you to take away to your team. There is also increasingly mission briefings, virtual missions that are happening. Number 3, talk to businesses that are already doing similar business in Southeast Asia region, through British Chambers, through Department of International Trade, through UK-ABC that is close enough to you for you to reach out to. Consult agents, distributors, and suppliers, because depending on the mode entering the country, you may be working with another partner and they need to know how best to safeguard your rights. Realize the importance of a sound business IP strategy and market entry plan. So while planning and strategizing, find out what are some of the best and available regional IP initiatives that you can leverage on. And finally, carry out your due diligence of your IP. There are free tools for a start for you to do a bit of exercise under the regional initiatives such as the ASEAN Trademark Design View and Patent Scope that allows you to search your trademark, design, and patent on common online database covering participating ASEAN member states. It's a website, Google style. You can key in your brand name. So for example, we could key in UK-ABC and see if that mark has already been registered in the region. It will be interesting to see the results. Speak to us and your IP lawyers when you are ready to see whether there has been previous registration of IP in the region. Otherwise, register your rights early. Take time to also explore these platforms as mentioned in the earlier slide. These are links and available for you in PDF after this session. Try running an exercise for your company and see what the results are for you. IPO has also a suite of online training tools that are available designed to help businesses. The tools are there for both business and business advisors, so useful for our DIT colleagues who have dialed in as well. Although that will be useful and helpful for anyone learning how to manage or use IP. They are free to use, and once you register, you have access to the business-focused resources. Now is the time to catch up with learning, so do share these resources with your team. And finally, moving on to the last area I would like to cover are some takeaways for you while you manage your intellectual property. You will need to also know not to infringe on others when you step out of the country. So here are a list of how we can go about managing your talents, your employees, your business development, executives who are very keen in getting sales, going out to the region and sharing all the bright ideas. How do you go about managing your choice partners? So after all is said and done, there is a need for a multifaceted approach. You will need a sound IP management and filing strategy in Southeast Asia. You will need also a proper licensing contract if you are looking to one, depending on your mode of entry. Who owns it? What is the business model? What data are you giving away? What rights are you commissioning? What fields of use? Which territory? Is it a whole of ASEAN? Is it just Vietnam, Indonesia, Philippines? Is it exclusive, non-exclusive? Do they have the right to sub-license to someone else? How long are you going to give it away before you review? Is it 1 year, 3 years, 5 years? So these should be covered comprehensively in your licensing contract. On technical publications precluding others from patenting the same techniques by publishing enabled data management techniques is one of the ways some industry players do. Managing trade secrets and confidential information. If it cannot be reverse engineered, the tactic will require implementation of appropriate company policy and employee agreement language. How do you go about managing the trade secrets when your employees have got access to it? Consider to protect your source code, register your trademarks early, and you must continue to monitor the market. Once registered, no one is going to help you actively monitor unless you procure services from professionals in this area and expertise. Know your competitors and players in the market. And finally, we have left you with a NDA, a non-disclosure agreement template, which you should keep a good record of who you sign with. Now, this is the case study I mentioned earlier. This is founded in the 80s. The company was set up to plug the gap in the market for roller skates. A one-time small UK trader is now today an internationally recognized company. It has a range of sports products, skateboards, scooters, etc. After success into the UK market, they then enter the Spanish market. And then very soon they follow up across Europe. They have now entered markets in South Korea, Canada, Russia 5 years ago, but have since expanded to Asia, Australia, and North America. So that's the scene of where they are. So what did they do? They put in a lot of effort in product development. Every product they make is unique. They seeing their product and IP copied is frustrating and counterproductive. They are always concerned about customers being misled and possibly damaging their reputation. Over time, they have refined a very systematic approach to registering their brands. Their in-house lawyers work with a local firm of trademark and patent attorneys to protect their brands across UK and Europe. Before making their applications, they checked that they wouldn't want to infringe on other registered brands. They did this by doing their due diligence, searching trademark registers in IPO and EU IPO. But to cut the chase, when they eventually looked to expand into the other territories, they did the same. And they don't do it by themselves. Besides providing professional services, they work very closely with DIT to get a sense of the nuances, the culture. Today, from where they are in the past in terms of export sales. It was 5%. Today, the figure is about 60% export sales. So their wealth of experience behind them and their advice to anyone thinking of exporting is, if you are a company which makes unique products, investment in IP is worth your investment for time and money. Otherwise, you really leave yourself open to your products being copied or passed off by rival companies. So to not be left behind is to constantly innovate and reinforce a commitment on your IP journey. I'm aware of time, so I'm going to leave this slide because with where we are now, these are some of the slides if you're thinking of entering some X market in mind. Look at some of the platforms that are available. World Intellectual Property Office organization have come up with a tracker to know which offices are closed, how to go about registering their rights when their office is closed. Finally, if you are looking to file your rights in the UK, is to look at the last link that will give you an important update on some of the disruption that we have. And finally, make a good home run, like we mentioned earlier. We have other attaches that are based across different regions, as mentioned. If in doubt, reach out to us in the first instance and we can point you and discuss. That's all from me now. Thanks very much for your attention.
Thank you very much, Christabel, for that good overview of IPO and your services, and particularly the tools that are available there for UK exporters, as well as the overview of the IP landscape. Thank you very much. That has generated some questions, which we will take later, but I do still encourage our listeners to send in your questions for our specialists, which we will discuss after our next presenter's presentation. So without further ado, I'll hand over to Victoria to go through the legal aspects of IP in ASEAN. Over to you, Victoria.
Unmuted now? I hope I am. Well, thanks anyway for the introduction. My name is Victoria Armstrong. As Paul mentioned, I'm a senior associate in the IP, digital and media team at Taylor Winters Via in Singapore. I've been asked to give a quick sort of 10-minute presentation about me, what I do, what our firm does, but then also a bit about the services that firms like us offer to UK companies looking to protect their IP in ASEAN. I'll be then very happy to join the panel in answering any of your questions. So Taylor Winters Via is an IP and tech focused firm. It's the Singapore branch of Taylor Winters, an international law firm with offices in London, Cambridge, Oxford and New York. Our clients range from Fortune 500 multinationals through to fast growth venture backed businesses, owner managed businesses, to individuals just starting out. I qualified in England and Wales, but I'm a registered foreign lawyer in Singapore at the same time. So I split my work between the UK and the Singapore offices. My focus is on IP protection and exploitation, IP litigation, and digital rights enforcement, amongst other things. I've worked in the UK, Brussels, Hong Kong, and Singapore. So hopefully I'm quite well placed to talk to you all today. My practice has predominantly related to the protection and enforcement of copyright, trademarks, reputation, and domain names. So one thing I should point out at the get-go is that whilst I do dabble in patent litigation, I'm not a patent prosecutor. My focus being on branding and content. I'm a so-called soft IP practitioner. But we do at the firm have highly experienced patent attorneys, both UK and Singapore offices. So if you have any technical patent specific questions, I'd be more than happy to forward them to my colleagues. So as a firm based in the UK and Singapore, obviously a large chunk of our clients are UK companies looking to expand. And what I often find from speaking to those clients from the get-go is that they're in a real rush to get into the market straight away, usually because there's a nice lead that they want to secure as soon as possible. And whilst that is tempting, From my IP perspective, I always ensure that my clients' IP is safeguarded, or its value is safeguarded before they rush in. This is especially true where your markets are international and multi-jurisdictional. So from that perspective, I'll now take a bit of time to briefly walk you through some of the things we typically recommend that UK companies consider when expanding into ASEAN. And I'll split these into 3 categories, so branding, confidential information, and content. So branding. When it comes to branding, the first thing you usually think about is your trademark or trademarks. Good trademarks, as Christabel has talked about, help you stand out from competition and allow you to take action to stop third parties infringing your brand. Nowadays, they're an essential part of pretty much any business. And so investing in your trademarks early can really help you build a strong brand, save you lots of time, save you lots of money in the long run. My top 5 things to think about before using or registering your trademark in Southeast Asia are as follows. So firstly, be distinctive. You can't trademark common or descriptive words, much as it is the case in the UK and Europe. Think about what goods and services you want to cover. Don't just register everything in the Southeast Asian region. Not only would this be extremely expensive, but you risk losing the trademark if you don't use it as registered. Think about where you want coverage. I typically advise clients to register their trademarks in their current markets, if they haven't already, together with their short to medium term, so around 3 to 5 years intended markets. Make sure you're the first person to use it. If a third party is already using or has already registered your mark in a certain jurisdiction, very likely when you're expanding into new markets, then that third party may have prior rights that could be used against you if you try to then register or use your mark. From that perspective, clearance searches really should be conducted before applications are finalised. And certain tweaks can be made if necessary to good specifications to avoid conflicts. And finally, invest now to save later. Trademark applications are considerably cheaper than the investment you would need to make to develop any valuable
Our apologies, I think we have lost Victoria Armstrong. We'll just give her a couple of minutes to see if she comes back online. Apologies for this. Let's just give her a couple of minutes and see if she's back on. Thank you.
I think my audio connection is back.
Thank you, Victoria. We just gave you a couple of minutes. Yeah, lovely. That's great.
Was I talking about domain name portfolios when you lost me?
Just before that, yes.
Yeah. Okay. So I'll just sort of go back to the beginning of that section. Apologies for that. So you need to think really carefully about your domain name portfolio when you're considering protection of your branding. The growth of e-commerce on a global scale has been joined by an increase in online crime and counterfeit dispersion, clearly. And so this can result in erosion of your brand value, profit margins, and cause loss to customer loyalty. So developing an adequate domain name portfolio is really it's an extremely useful addition or alternative to protecting your global brand. When you're developing your strategy for domain name purchases, the key is to reduce the chance for others to use your brand name in their online activities, so specifically in their website URLs. A strategy for domain names can be complex, so large companies with household brands might own hundreds of domain names, but small businesses that don't have budgets just need to ensure that the basic steps are taken at the very least. So some of the key considerations that I usually put to my clients are the following. Think about common extensions. If you do nothing else, be sure to register your domain names. So domain names that include your brand name with the most common extensions, so .com being probably the predominant extension. Common misspellings and obvious variations, so typos, hyphens, make sure you register all those variations. For example, Hello Kitty would register hellokitty.com as well as Hello Kitty with one T.com, for example. Phonetic equivalence, so a company with a brand name Wears Like New, W-E-A-R-S, might also register wearslikenew.com, W-A-R-E-S. Plural and singular variations, if your brand name is singular, register the plural and vice versa. One of the key things to think about when you're expanding your markets, especially coming into Asia, is to think about the different country level extensions for your domain name. So for example, you might register .sg for Singapore. There's also in recent years, probably in the last 5 to 10 years, been a huge expansion of the available domain name extensions. So that includes the controversial .sucks domain name and many, many, many more. So the options go far beyond generic and country-specific domain names. You might think about .data, .tech, for example, if they're available. This probably isn't a priority though. I think save money in the first instance and just register those key options. So the second category of IP protection, as I see it, is confidential information. Aside from branding, you want to protect your ideas, your designs, your inventions, know-how, and other confidential information before diving into a market. Many jurisdictions in this region, including Singapore, have the rule that follows the UK, for example, whereby the creator or inventor of IP is considered the first owner. This presumption is overcome where IP is created or invented in the course of employment, or where the ownership position is governed by a contract that states otherwise. So regardless of whether you choose to register your designs, your patents, and other IP, I would always recommend ensuring that you have the contractual protections in place for your confidential information as well. Indeed, much confidential information can't be registered. For example, certain know-how, customer lists, etc. So at a high level, some initial steps to follow in protecting your confidential information contractually might include implementing a tailored trade secrets policy to form part of your company handbook, collating your trade secrets or confidential information in a central repository and making sure that information is marked confidential trade secret. Only permit access on a need-to-know basis to that information. And for those people who do have access, make sure they're signing NDA. So that might be in employment contracts or consulting agreements. Require employees exiting your business to sign an exit letter confirming that they've destroyed or returned any confidential information in their possession and agreeing that they won't use it in the future. These points are really just the minimum steps that should be taken. The final category, as I see it, is content and IP protection. Your content will typically be protected under the law of copyright. In Singapore and most other jurisdictions in the region, copyright arises automatically, and that happens upon the creation of a tangible expression of an idea. So in a written document, copy on a website, an image, a video, source code of software, and it generally lasts for the life of the author plus 70 years, though there are exceptions to this duration, and it will vary depending on the territory in which the copyright work was created. In certain jurisdictions, including the Philippines, for example, certain copyright can be registered, and this makes proof of subsistence and ownership easier and simpler, so I really recommend it if it's possible. That said, most countries in this region don't offer copyright registration. To sort of get around this, I would recommend including a copyright notice in all content and literature that you make public. So for video content on your website, for example, it would be really helpful to include a copyright notice during the introduction and again in any credits. A copyright notice will really need to be accurate, obviously. So if a particular element of that content isn't owned by you, make sure the third-party content owner is named. It should also reference the date. So I would suggest that a notice would take the form of the copyright symbol, so C with a circle around it, name of the owner and year created, and if it was created over time, then a date range is absolutely fine. So that's my very, very brief whiz through of the key considerations to think about from an IP perspective when you're entering the markets here. But before I forget, in conjunction with the IPO, we're offering 1 hour of free legal advice for the first 3 attendees to get in touch. So please feel free to reach out to me, and I'll hand back to Paul.
Thank you, Victoria, for that insightful presentation there, without slides as well, which was fantastic. A lot of information there, a lot of information about do's and don'ts, what you should be doing, what you shouldn't be doing. And I think many of our listeners will take you up on that 1 hour of free advice, because it sounds as though it is a little bit of a minefield there, but that's why there are organizations like yourself to bring that all together and take that pain away from UK exporters. So look, that has generated a lot of questions. I think we can take a few here. We're between yourself and Christabel, I think. Let's get Christabel back on video. Yeah, lovely.
Yes.
Okay, so there's about 3 questions here which are really all linked, and it would probably be great to get some comments from both of you. But you did cover this one a little bit, Christabel. So if we start with you, and we've got a question here in from Terry, which is, can I file a trademark application which covers multiple ASEAN jurisdictions?
So the answer is yes. Yes, you can. And the way to do is a recap on what we went through. There are 2 ways to file. One, to go direct. But I think the answer to the question is the second mode, which is to file a registration, a trademark registration with the World Intellectual Property Organization under the Madrid system. And that's where you can indicate those participating countries that are signatories to the international agreement. So the registration is in place. So in short, yes, you could. You have to use the Madrid system. And if Victoria would like to expand, we are more than happy for you to do that, but happy for you to reach out to us, who is asking us the question, and we can bring you through the process.
Yeah, what would that look like, Victoria?
Yeah, so there's not much more to expand. It's a very similar process to applying for a trademark nationally or directly, as we call it. I think, correct me if I'm wrong, Christabel, but I think all of the ASEAN countries have signed up to the Madrid Protocol, with the exception of Myanmar so far.
That is right. So the latest addition that have joined is Malaysia. So one of the things, the wider things IPO does is, beyond our business and trade sessions like this, we work very closely with local governments, 10 of them, to try to accede as part of their WTO TRIPS agreement that they have way back. One of the requirements is for them to accede to IP international treaties, such as what we have mentioned, PCT, Madrid for trademarks, getting them and helping the countries and the office to set up in place, make sure the process is in place to join such international treaties, because they are more beneficial, more effective, more efficient for exporters to be registering their rights across the countries. So where we are in terms of Madrid, yes, we are short of Myanmar, but very soon, and we have all the help in place to help Myanmar IP office to have that in place.
So to answer Paul's question, the process, obviously I won't go into acute detail. But when you're making a Madrid registration, you'll need as a base a trademark application or registration that you can use to start the application. So normally you'll have made a national or a direct application. I often recommend that is a key market for you. So you might use your UK trademark, for example, as a base to your Madrid application, or if you have none, I might recommend Singapore as a base, largely because Singapore law is often influenced by lots of other jurisdictions, trademark law and IP law. So it's quite useful to have a base in a country like that, so you can anticipate any potential amendments you might have to make to the application. So you'll have a base application or registration. You will then file an application through the intellectual property office of that base marks country, and it will be one single application. There'll be an additional charge per country or designation that you add to the application, but it's fairly easy to state that it's a much more cost-effective process than filing separate applications for each country. That said, filing a Madrid application, there are some stumbling blocks. So you may often have to make much more. You might have to tweak your specifications, for example, your descriptions of your goods and services that are covered, because different countries, of course, will have different criteria to follow and different standards to follow. So that can make it a little bit more complicated. But on the whole, like Christabel said, these kind of agreements across multiple countries are really, really efficient and very cost effective.
Yeah. I will, you said you weren't going to go through the process, but I will push you on the process a little bit, because we've got another question here which is associated with cost, because you know, if you're registering your trademark, if you're registering your patent, if you're registering your design, there's a huge amount of work there. So the question that we've got in here from Ben is, what are the costs associated with trademark registration, and how long does the process take?
Mm-hmm. The
$1 million. That one up, Vic? Victoria?
Yeah, sure. So it really depends on lots of different variables, including the number of goods and services or classes of goods and services that you wish to be covered under the application, whether you use standard or bespoke specifications, so standard or bespoke descriptions for those goods and services that are going to be covered under the trademark. The number of jurisdictions that will be included, obviously, and of course whether you intend to use the Madrid system or direct filing. Costs also increase due to extra advice that you might need, which I would always recommend. So pre-filing advice to make sure your trademark is actually registerable, conflict checks, clearance searches to make sure there aren't any prior rights that are going to conflict and not only slow down your application, but potentially void it. But also, if the application is opposed at any point by third parties, that will increase the cost. But generally, a simple unopposed application in, say, 2 goods and service classes, which is perhaps the typical number in Singapore alone, would cost around, in total, probably £1,000, and that includes lawyers' fees, official filing fees, etc. On the other hand, if you were to apply for a multi-jurisdictional, multi-class application, say 10 countries, 4 classes, that could come to around £15,000 to £18,000. So there's a really, really, really wide price range, and it just depends how much you want, how much coverage you want, how many countries, etc., etc. I'd say in terms of timing, I've had a few trademark registrations come through in as early as 4 months before, but sometimes an application process can last up to 18 months or perhaps even more if the mark is opposed, there are lots of conflicting prior rights out there, whether amendments need to be made to the specifications that you've drafted by certain intellectual property officers. So again, quite a wide range, but you know, it can be really quick if it's a simple application.
Yeah, yeah. There's a lot to consider there. What support is there, Christabel, to UK exporters to try and make that cost a little bit more gentle for them?
Yeah, unfortunately, I haven't got the voucher for them to claim against. But my suggestion is when you're ready to embark on it, get in touch with us. The reason for that is one example, Singapore. Some good years ago, there were grants and incentives in place, schemes for registering your IP rights, but they have requirements. So the requirement is you need to register your office in Singapore, etc., and you meet a few requirements. And then there is a sort of like voucher, a grant, a scheme for you to offset some of the registration. So that scheme is no longer available in Singapore, but there are related schemes that out of the wider scheme of business doing and exporting your services, there are maybe some that you could tap on. So as we speak now, I think it's easier for everyone to take it back home, decide where is your foothold, where do you want to register? You can't register the whole world; it's just too expensive. So having a good thought, get in touch with us. Let us be a sounding board to you. Let us update you. You know, for the X market, this is what is available, and then who do we have to handhold you? Are there partners that we can link you with? Government, for example, who are running those schemes to make sure that you have the right requirements to tap onto those schemes to enter the market.
Yeah, that's good news that there is there, because this has come up in a question actually from one of our listeners here, which is the best way to approach the IP strategy, and what are the key considerations when planning, because obviously there's a lot of work to do here on getting that strategy right so that you're going into the market fit and well and prepared. So yeah, the question is it best to speak to lawyers in the UK with ASEAN experience, or go straight out to the UK-based lawyers in the region like
now,
Victoria?
my take is there is no one strategy that fits for a business, because if there is, we'll make sure it's online and people can copy and paste, tailor to their business. There is no one strategy, because every business and the mode of their engagement is different. Some come in as a joint venture, some come in to set up as a fully owned subsidiary, some based on the franchising mode, etc. So based on the different mode, you have to flex the strategy and entering each of the diverse market that you've mentioned, and with a legally fragmented business environment for them to do business, there are a lot to take in country by country. You can have a regional approach to enter the country, and that regional approach, which country are you entering first in Southeast Asia? So that's the regional. But when it comes to individual market foothold and market entry, you have to flex and give yourself enough room to maneuver. And this is where I think the core business team, the key decision makers have to come in to sit down together, to argue, to toss ideas around, to think and say why this market is better to enter now than later. Singapore may not be the answer to all the entry point for Southeast Asia or APAC. There are a lot of emerging markets that are a lot more cost effective and easy to set up in the region. So my take is the core business team has to sit down and talk about how they want to enter. Until you have the answers to the legal professions or the strategies or the IP business consultants that are available in the region. And then that's where they ask, where is your foothold? Who are your target audience? Who are you going to sell through? What is your mode of entry? JB? You know, so there are a lot of consideration to this. And to make it work, first, home team, make sure you get it right, so you have the answer. Two, when you think you are ready, start engaging professionals. Now, one step before that is a baby step. There are webinars like this, there is mission briefings, there is trade mission that UK-ABC arranges, there are chambers, 10 offices in ASEAN who have people on the ground, and there is DIT team that hopefully within one of your sectors, you have someone to talk to. They will know the latest schemes available, the best way to enter. So use these free resources that the UK provide for UK exporters, and then go into our partners like Victoria and the rest that can really handhold you into the region and expand.
Yeah, you're absolutely right, and it is part of companies' export strategy, because companies are not going to just dive into the 10 countries of ASEAN. They're going to, with the help of organisations such as yourselves and the Department for International Trade, they're going to look at where the potential is in the ASEAN markets for their products or services, and possibly look at 1 or 2 markets initially to get established, and then to grow into the region. We've got a couple of questions that come in that which look like a bit of a horror story, which we'll take up. But I'll pitch this one to you first, because those 2 questions are based around this one really. Is that, and I have some personal experience of this in a former life in a different part of the world, but can IP infringements realistically be enforced in the region? I'd like to get a comment from Victoria first, I think.
I mean, that is a question that I think you could spend all day answering. There are so many elements of this, but the short answer is yes, absolutely. The key to that is having registered rights. It makes it so much easier to enforce your rights if they're registered. Many countries in this region do absolutely protect unregistered rights. We have laws such as passing off that help with that. And obviously copyright, there's a huge copyright framework in the region, and copyright rises automatically. But in terms of registerable rights, register them, because it's just unregistered rights, whilst you can protect them, gathering evidence to back up your rights to those elements, it can be really costly, really difficult. You often have to have fairly extensive use in that region before you can enforce unregistered rights. And yeah, it's much cheaper to just make sure you've got all your registration eggs in a row first. But yes, enforcement in the region is very standard. I'm involved in it a lot, not only through the courts, but the Intellectual Property Office of Singapore has a very good enforcement strategy. So you're able to cancel certain rights if they conflict with your prior rights. There are opposition mechanisms that are very systematic and easy to use. In terms of enabling the enforcement in this region, I'd say, I think Christabel touched on this earlier, but putting in place monitoring systems is really, really important, because you can be one step ahead of the game. Because I think when it comes to enforcement of your rights, speed and time is of the essence. Often you can have a bad faith trademark filer who has managed to get away with using your rights or infringing your rights for, or not even a filer, just an infringer, has been getting away with using your rights for 5 years. And if you hadn't noticed, they can argue that, you know, they've been using your rights by consent. So, you know, speed is really, really of the essence. In terms of sort of the sort of digitization of the world and of this region more recently, another point to add in terms of having registered rights and that being so important is that domain names, which I was talking about earlier, registrars of those newer domain name extensions have adopted a sunrise period for registered trademark owners. So that allows you to enforce your rights through ownership of URLs, domain names, during the sunrise period. People who haven't got those registered rights are prevented from registering domain names in that time. So again, it really, really helps with enforcing your rights early on. From a copyright perspective, because I'm sort of steering towards trademark this whole time, I realise I'm doing so, but from a copyright perspective as well, the region is really catching up with Europe and the UK. Recently, Singapore has had a fairly huge overhaul, and it's still going on, fairly huge overhaul of its legislative framework when it comes to copyright, just to help enforcement, to help support creators in the digital age. So that's really, really good to see. There are all sorts of mechanisms for enforcing. So yeah, long-winded answer was that, but short answer is yes, absolutely. Enforcement in this region is definitely possible.
Just
Thanks
to give a
very
quick plug-in before, I mean,
yes, Christabel, we are near the end
one of the
snappy.
yes, one of the things that we are doing very closely is to help the IP officers to play a more proactive role in terms of IP enforcement. So that's where business and trade one, we do IPO, we also work on enforcement. Very recently, we have programs that are running on enforcement. So if any of you have issues enforcing your rights, come to us. We may not be able to solve your issue, but we're able to flag this to the authorities, to our contact, to see what they should do, how should they go about doing it, and then we can go on to your local region. So for example, very recently, IP Office of Philippines, if you find anything that's infringing your rights, get in touch with a unit that's recently created, the IP Enforcement Office. You can contact them through social media means, Facebook, etc. It's just as easy as that to enforce. Now, if it belongs to you, it should matter to you enough to get in touch with the authorities. So you can't blame people copying because, yeah.
Lovely, thank you, Christabel. I mean, we could continue to talk about this for a lot longer. We do have a few more questions, and we will get back to those people that have asked those questions. But unfortunately, we have come to the end of our webinar. So I'd just like to thank both our speakers, Christabel and Victoria, for a very good overview and enlightening session on intellectual property in ASEAN. And to all of you, our attendees, we trust that was useful for you. I think the message is very clear that when companies are preparing to access a new market, you should prepare an IP strategy to protect products and services and therefore prevent loss of revenue further down the road. Finally, just to mention again that our next webinar event in the UK-ABC Digital Export Series, Future Opportunities for Higher Education in ASEAN, next week, 18th of June. Registrations are still open and we look forward to seeing you all there. Goodbye and enjoy the rest of your day.